So the Attorney General, in order to preserve for as long as possible a law that they absolutely know is unconstitutional, took this back road deal in order to keep this illegal law on the books. Now, before we get into that, a quick reminder. The USCCA has a secret giveaway that's going on right now, and it's completely free to enter, and it ends really, really soon. So just click on the link in the description to reveal what it is, and here's a bit of a hint, it fits in your holster. All right, with that, let's talk a little bit about California Penal Code Section 26150, specifically Section 1. Now, for those of you who live in California, you know that up until relatively recently, getting a concealed weapons permit was pretty much designated as an arbitrary decision that was made by your sheriff. Now, with the Bruin decision, specifically New York State Rifle and Pistol Association v. Bruin, we now know that we are effectively a shall issue country. There's been some pushback on that, to be sure, by not only issuing agencies, but some courts and some Department of Justices throughout the country as well. But academically, we now know that at the very least, the applicant's requirement that they state a good cause is no longer deemed to be constitutional because of that Supreme Court case. Now, I do want to get a little academic on this for a second, because it's not just simply that good cause does not exist. In the opinion, New York State Rifle and Pistol Association v. Bruin, Justice Thomas was very, very specific. He said, this is a constitutional right, the bearing of arms outside of your home. In fact, that was actually the fundamental component of the case to begin with. Where does the Second Amendment actually exist? Is it something that's relegated exclusively to one's home or to one's business? And the Supreme Court said unambiguously, no. The Second Amendment exists outside the home. And as a result of that, a person needs to have the ability to be able to exercise that right. Now, effectively, there are only three ways where you could exercise that right. You could openly carry your firearm. That, if illegal, would be an appropriate way to be able to exercise your right to bear arms. You could live in a state that allows for constitutional carry. Effectively, the state has punted and effectively said, look, we don't even want to get involved in this. As long as they're a law-abiding citizen, they can carry a gun without any permitting process required. Alternatively, the court said, look, getting a CCW is legit. The state can go ahead and license this. Now, I will tell you there are some sort of philosophical issues that I have involved with that, but that notwithstanding, they didn't negate the requirement for somebody to actually get a CCW if the state requires that. However, getting the CCW must not be too onerous. They can't make you wait 5 years to get a CCW or post a huge bond or have application fees that are unreasonable. Those types of things might be construed as being an unlawful burden on your ability to exercise this right. They also said, very specifically, that the issuance, or rather the denial, of a CCW must be based on objective criteria. It's not something that's subjective based on what a particular magistrate feels about the applicant or about the underlying Second Amendment itself. So effectively, the getting of a permit has to be objectively based. Now, that all being said, in California, specific to California Penal Code 26150, there have been three specific things that are required to getting a CCW. Under Section 1, you have to be of good moral character. Now, we'll be discussing that here in this particular video. Under Section 2, you had to articulate a good cause, why you were somehow different than the rest of the general community, why you should be allowed to actually carry a gun outside of your home. And lastly, under Section 3, you had to actually prove that you were under the jurisdiction of the issuing agency to begin with. You know, if you lived in Los Angeles County, you could not apply to the sheriff in Orange County since you weren't under their jurisdiction. Well, the second requirement that you show that you have good that you have good cause, well, that was negated under New York State Rifle and Pistol Association v. Bruin. That code section was specifically called out as being unconstitutional. But like I said, in that decision, the court stated that the issuance or denial of a permit must be based on objective criteria. So that begs the question, under 26150A, what is good moral character? Now, I'll be quite candid with you. I don't know what the hell that's supposed to mean. I mean, I can tell you that certain individuals judging my moral behavior might construe that it fails to make their standard. I will also tell you that there are individuals out there that I consider don't engage in good moral behavior. But that's a complete arbitrary designation based on my own value systems and everything else. It's not something that is oriented towards the state. And more importantly, what the hell business is it of the state for making a determination as to whether or not someone's engaged in, immoral behavior? I mean, immoral behavior specifically oriented towards the breaching of a law that implicates someone else. We might have a legitimate debate about that. But, if you have a number of parking tickets, does that suddenly construe itself as being of lacking of good moral character? Or perhaps if you've engaged in, some form of gambling, is that an indication that you've engaged in immoral behavior? What if, like me, you like to hunt? I can tell you right now, in California, there are a number of people that consider hunting to be antithetical to good moral character. Should I be denied a permit because my particular issuing agency, the person is an animal rights activist and doesn't like the fact that I go afield? So it's vague and it's ambiguous. And in my opinion, it's also negated by the Bruin decision. Now, what's interesting is that I suspect that our Attorney General in California, Attorney General Banta, also believes that it is unconstitutional. And there's a specific reason for that. It's a law case that got filed a number of months ago called Ellis v. Banta. Now, I want to kind of get into this case because it's somewhat instructive and shows, in my opinion, unconstitutional conduct on the part of the Attorney General himself. So, in my capacity as one of the instructors here at the Artemis Defense Institute, I was doing a CCW class. I do CCW training for many of our clients. One of our clients was a gentleman by the name of Norm Ellis. Well, Mr. Ellis went through the training and applied for a CCW with the Sheriff's Department. Now, interestingly enough, this all happened post-Bruin, okay? So the good cause requirement, that's gone. Now, Mr. Ellis is a retiree, had been an aeronautical engineer. In fact, he owned at one point his own aeronautical company. But it turns out that back in the late 1970s, Mr. Ellis, while he was 18 years old, decided to do a little personal learning adventure by stealing an airplane. You see, Mr. Ellis desperately wanted to be a pilot with no flight experience at all. He got himself liquored up, went over to John Wayne Airport, which at the time was really nothing more than an airfield, and he stole an airplane, taught himself that evening under the influence of alcohol how to fly around Orange County. I think the fact pattern is just unbelievably awesome. But he He did this and was subsequently arrested when he landed. Now, they really didn't know how to charge him. I mean, after all, he didn't actually steal the airplane. He was effectively joyriding in it. So they ended up charging him with a misdemeanor. Well, the background investigator at the sheriff's department was utterly appalled. I mean, this individual, granted, 30 years ago, stole an airplane. I mean, we cannot allow this person to get a CCW. So they denied him. He asked me if I would bring an action against the sheriff's department. And I told him, look, I provide legal services to the sheriff's department. I'm going to be conflicted out of that case. But I referred him to another attorney. So this other attorney, David Flyer, ended up filing a lawsuit against the attorney general. And it was an interesting legal theory. Rather than suing the sheriff, he would sue the attorney general and he would file what's called a motion for declaratory relief. Effectively, he was going to challenge this code section that required a finding of good moral character as being in violation of the Bruin decision and therefore unconstitutional. So the theory was have the code section invalidated as being unconstitutional and then have Mr. Ellis reapply for a CCW, and he would not be able to be denied for this now unconstitutional statute. Well, it never got that far. About 2 weeks before trial, the powers at the Department of Justice must have been looking at the pleadings, looked at the underlying arguments and said, oh my God, we are going to lose this. And when we lose this, that section 26150 will be decried as being unconstitutional, and nobody will be able to deny anyone throughout the state of California a CCW permit for lacking good moral character. So knowing full well that this is an unconstitutional law, another way of saying it, it's an illegal law, let's go ahead and pressure the sheriff to issue Mr. Ellis a permit right now. And that's exactly what they did. Suddenly, Mr. Ellis was given a permit, sort of sua sponte. Here you go. This now did what we call mooting out the case. Since Mr. Ellis now had a permit, there was no longer a case in controversy, and the case was ultimately dismissed. So the Attorney General, in order to preserve for as long as possible a law that they absolutely know is unconstitutional, took this back road deal in order to keep this illegal law on the books. I believe that it will ultimately be challenged. It will ultimately be found unconstitutional. But in the meantime, most of the issuing agencies themselves have come to the conclusion that denial based on the general concept of lacking good moral character is probably not going to fly. That they are going to have to show why you as an applicant should specifically not get a CCW. This then gives you the right to bring a legal action against the issuing agency, where they now have to prove to a judge why the background information prohibits you from being able to carry a gun. Not that it prohibits you from owning a gun. And this becomes an interesting plot point too, right? So if you are legally allowed to be in possession of a gun, then the presumption should be that you are now legally allowed to be given a CCW permit to carry that gun. Again, the presumption is going to be that. It will have to be now the issuing agency that goes to court with specific evidence that is contrary to that presumption. They need to show why you, as a specific individual, should not be allowed to have a permit. They still theoretically could hang their hat on 26150, but I believe that gate is closing very, very soon. Until then, if you have any questions at all, always feel free to email me at stephen@ltccwlaw.com. All privileged communications should go through that email. If you have general questions, of course, you can email me at stephen@artemis, ARTEMIS, HQ.com. Until then, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.